Right, let us start. Good afternoon again, and welcome to our panel, Comparative Law Studies in Context, the Challenges and Opportunities of Translation. I am very pleased to be part of this panel. It is an honor, actually, to present together with Pia Letto-Vanamo, Dean of the University of the Faculty of Law of the University of Helsinki, Vernon Valentine Palmer, the Thomas Pickles Chair and co-director of the Eason Weinmann Center for Comparative Law at Tulane Law School, and Markus Puder, Markus Puder, the Honorable Herbert W. Christenberry Professor of Law, Faculty Director of the LL.M.Program at Loyola University in New Orleans College of Law. So welcome all. And this conference puts us a challenge. And is calling for a systemic dialogue between comparative law experts and historians about the methods and goals of comparative legal history. And when we were putting this panel together, we considered that the first step for such a conversation is translation. Given that legal scholars and historians operate within different conceptual frameworks, methodologies, and linguistic rules. However, the differences do not surmount the similar challenges that both legal scholars and historians face while pursuing their endeavors. There are several circumstances when they all have to translate. If the legal scholar uses the comparative method, they will have to translate, even if the language in which the law is written is intelligible. The translation is inevitable if the legal scholar approaches law from a social sciences perspective and seeks knowledge beyond understanding its effects. The legal scholar can only comprehend the law beyond its effects if they know the history of those laws and learn the options that were available to legislatures at a particular time. Likewise, historians translate before interpreting, and their translation efforts derive from their linguistic analysis engagement as they search for an understanding of legal concepts in a foreign context. Now, our panel addresses the circumstances I have just mentioned that compel legal scholars and historians to translate. The papers that our panelists drafted explore the many ways in which researchers, legal researchers and historians translate. And our panelists derive broader impacts, one of which being the creation of methodological tools that firmly lie on interpretation and translation of foreign concepts as a precondition of a fruitful dialogue between two different disciplines. So I will follow the order of our panel, and I will start presenting my research and hopefully convey the message that is without moving or to move forward. The first step really is to translate and understand the concepts in context. So I will share my screen with you. Which is always a dangerous thing to do. All right, I hope you can see this. So This is the research project. I get a message that it is visible. Thank you for that. This is the research project, one of the research projects that I am working on at this point. Countries. The recent challenges the world is facing have revealed staggering levels of inequality, which the current economic model has not been able to overcome. And indeed, some consider that the current economic model is flawed and should be revised. Climate change, blatant global inequality, extreme poverty, and the unaccountability of weak and disengaged institutions are some of the phenomena that have been enhanced by an economic model that exclusively identifies prosperity with economic growth. The current economic model, as we know it, needs to be reinvented, for it has been numb when it comes to responding to new challenging contexts. The African continent is not insulated from the challenges the rest of the world faces. There is not a supposition that it should be. Indeed, Africa must assume the world's challenges on top of a systematical disadvantage starting point. Despite the wealth of natural resources and human capital, the African continent is still lagging in the race for sustainable economic growth. However, we must contextualize the concept of sustainability. We must analyze this concept within a spectrum. The world has never been as connected. Our global interconnectedness is visible and inevitable in an age of technological revolution. However, culture, as much as it is a representation of reality, is informed by history. In turn, history is composed of stories that build common morality and people's convictions. Therefore, the consideration of consumption patterns, the political discourse, and the essence of legal institutions must not be measured in the same way for defining sustainability. There is not a model of sustainable development that fits all countries. Hence, considering the history, the people's beliefs, and the people's understanding of fundamental principles such as equality and solidarity, I analyze the extent to which law can play a transformative role to nudge economic development that is sustainable. The project stems from the following research question: how can global connections and cultural ruptures with the past lead to the sustainable development of economic infrastructures in South Central Africa? To answer this question, I analyze the type of legal foundations that would enhance the global connections of Southern African countries and potentially break entrenched patterns of underdevelopment in the region. I take a comparative approach to this research question, and I select one country in the South Central region of Africa, Angola. I compare Angola to another country in East Central Europe, Poland. And I apply a comparative matrix that works as a laboratory for comparison between the two countries. Now, this is where translation comes in. Why these two countries? Well, Poland has seen tremendous economic development. It comes from a past, from a socialist past, and Angola comes from a socialist past too. Nevertheless, Angola is a country that suffers from scars of a deep war, and it doesn't have a lot of resources, such as funding from a transnational organization, like Poland has coming from the EU. So is it really possible to make this comparison? Should I be careful when comparing? Should I be careful when choosing or selecting the terms of comparison? And so, considering all these questions, I decided to adopt in this research project this comparative matrix. And it is a two entry table where on the left side, as you can see, I list or outline the terms of comparison in the form of questions. And on the top right side, I have the jurisdictions that I'm comparing. And being very careful and mindful of the history of the two countries, the geographical location, the culture, the first step that I have to take is precisely to translate the conceptual framework that I mean to use. So these are the questions that I'm asking, terms of comparison that I am outlining. Is there a historical record of disobedience of the rule of law and resistance to the implementation of democratic institutions? Has the international community, such as non-governmental organizations, international organizations, and other nations, contributed to the development of the country? Is a low infrastructure stock correlative to low levels of development? Is the country's market structure supportive of the development of new legal and economic infrastructures? The two main objectives of my project are the following. First, I intend to offer a set of legal tools and policy proposals toward the adoption of a social economy that does not rely exclusively on the extraction of natural resources. And the idea of socially non-extractive economy entails development of third sector organizations such as social cooperatives, solidarity financial institutions, associations, foundations, voluntary organizations, community organizations, community groups, social enterprises, and intermediaries, sole proprietorships that are more attractive for people to implement and lead to the creation of jobs and diversification of the economy. And the implementation of non-extractive economic practices is led by small-scale experimentation with the support of non-governmental organizations that appeal to the sense of community, accountability, and the principles of equality and solidarity. Nevertheless, all these ideas and principles are perceived differently in both countries. And I hope that after we initiate the discussion of the papers in our panel, I will receive comments on how to translate and how to use this matrix for the translation in a way that is fair and truthful to the history of each country in order to meet the goal that I am proposing in this project. Thank you. So let me stop sharing, and our next speaker is Pia. Letto-Vanamo. And her paper is Defining Past Phenomena with Current Concepts, a Dilemma of a Legal Historian. Yeah.
Thank you. Dear colleagues, greetings from Helsinki, from Finland. Thank you, Lécia, for inviting me, but also for proposing this panel on the questions about translation and languages. Questions of language and translations are crucial to me, not only as a legal historian and a comparative law scholar, but also as a scholar living in a country with a very exotic language, Finnish, writing mainly in foreign languages, in Scandinavian languages, in German and in English. During the last years, I have been working in an international research project led by Hans Miklitz from the European University Institute with the topic external dimension of European Union private law. We have been analyzing global impacts of so-called European Union regulatory private law. This means consumer law, financial market law, energy law, and telecommunication. Mainly, we are talking about regulatory private law, which means we are talking about a sector-specific regulation by the European Union and looking at how the impact or how it impacts worldwide, and we can see that it really impacts. In the project, many theoretical, political, and philosophical questions have been discussed. One of them has been about the nature of so-called transnational law. The nature of international soft law, I mean international standards, and so on and so far. These questions, however, are also crucial in debates in legal history. Questions that have been asked are partly the same Tamara Herzog yesterday asked. Namely, where does the law begin? How or where does it get its legitimacy, its acceptance? How do we define law without the Weberian pre-understanding? How do we understand law that is not modern, not national, not given, and not positive? Thus, is law also or always only pre-modern, modern, and late modern? And what does it mean that something is called as law, as we do in English in many countries and in many language areas when we speak about soft law as soft law? Or when we Europeans are calling or naming local customs as customary law? The other project I'm working with is about comparative supreme justice, inspired by a presentation in the World Conference of the Academy of Comparative Law by Sabino Cassese, a former professor but also a justice at the Italian Constitutional Court. In his presentation 10 years ago in Washington, he was talking about constitutional law judges as an epistemic community, discussing about constitutional review, but also about constitutional rights, human rights, and very often also reading same cases, but also the same constitutional literature. In other words, it's about not only about the epistemic community, but also about readers of so-called world literature in constitutional law, as the first president of Hungarian Constitutional Court, Professor László Zolin, said, it's always about Weltliteratur when constitutional issues are discussed. This project has brought me to issues of law and globalization, the missing global legal history, with questions about interaction between the global knowledge and local practices or local reality. Very often, legal concepts, even legal language, belong to what I call knowledge. This is an introduction to my thoughts, which I would like to discuss with you then later. But I would like to discuss a little bit more my ideas, mainly now as a comparative legal historian, or as a lawyer who knows history and is interested about comparison, and especially the comparative method. To me, researching history is like researching foreign cultures. Whether we are investigating medieval history or 19th century life in China or indigenous American peoples of the recent past, in each case, we are dealing with culture that is alien to us. Researching history is closely connected with the interpretation. When we try to understand, try to do right by the object of our research, the ideas and institutions of the past, we interpret it, but also at the same time argue for the interpretation. Actually, by engaging in linguistic analysis, we legal historians are doing translations, as we try to understand how certain legal terms have been used in a foreign context. And at the same time, when we explain the meaning of an expression, we translate it. However, operating with legal terms and concepts can often lead to misunderstandings if we assume that above legal sources stands a suprahistorical level to which linguistic findings belong. This is especially a danger when studying legal phenomena. Namely, legal language is bound by tradition, it changes slowly, and is even resistant to changes. I see very often that too easily we, legal historians, who are usually educated in law or even in legal dogmatics, are led to believe that we can identify in old or alien texts phenomena that are familiar to us from our current legal systems. Too quickly, meanings of past circumstances are changed into current ones, and seemingly similar legal problems are defined inaptly with identical concepts. I could refer to the concept of customary law, constitutional review, etc. This positivist approach to legal terms and institutions can be found unhappily also among other kind of historians too, not only among legal historians. Still, I think it is quite impossible to discuss, for instance, dispute settlement and its legal historical dimensions without using legal concepts, current and former ones, since concepts are to us links to professional discussions, links to discussions about law and legal culture, also globally. To speak about interpretation is almost impossible without touching upon problems concerning language. Researchers of language, linguistics, and philologists often read the same texts as legal historians. It is well known that many of the oldest written documents are legal texts. For instance, it is noteworthy, but not only from the perspective of linguistic history, that old Icelandic and Swedish legal texts used to begin with the word nu, if, and that old Anglo-Saxon legal documents were often written using the so-called double conditional. To a legal historian, however, these are the foremost signs of the casuistic and concrete nature of legal thinking of people in pre-modern times. It is also well known that language has both a present day and a long-term function. It is a tool of daily communication, but also a tool of cultural accumulation. Today, however, legal language is also a professional, and very often also specialist to specialist language. Still, we know that legal language emerged before the legal profession was born. It is possible to speak of the language of legal life, which can be understood as a functional language connected not only to the typical content, but also to the typical functions of the legal domain. This is the reason legal language is often bound to special ways of acting and to formal positions. This can be seen, for example, in the term in German language, Rechtsprechung, speaking about law, or the Scandinavian word Rättegång, which is like to walk to the law. Similarly, in the Swedish and German languages, for instance, law, recht, means right, but rätt was and is also synonymous with the word court in German Gericht. This explains at least partly the fact that very often terms relating to the field of procedural law are older than those of substantive law. Court procedure, its rituals and forms played an important role in the understanding of law. Indeed, it can be argued that law, opinion, or consensus about the right law in the case concerned emerged through court procedure. But we also know that there are countries with very young and very old legal profession, but also with old and young legal languages, which also make translations challenging. You have temporal variations in German language, but not so many in the young Nordic for instance, the young Nordic legal languages, which also create an illusion on continuity or of an historical space or legal terms and of a historical space of legal terms and concepts. Thank you.
Thank you, Pia, for this fascinating presentation. Thank you so much. Our next presenter is Vernon Valentine Palmer, and the title of his paper is Living Off Translations, the Survival of Civil Law in South African Mixed Jurisdictions. Vernon, you have to unmute yourself.
There. Is that better?
Better.
Thank you very much. It's great to be with you, colleagues, to discuss the challenges and opportunities of translations. I think that's our general theme. Greetings from New Orleans. I hope all of you are well. I'm honored to be a part of this panel. I'm truly honored. And my greatest thanks are to Professor Vicente for taking the lead in organizing this and for submitting our topic to the ASCL. My talk today will be an attempt to describe the role, the critical role, that legal translations sometimes have played in the survival of civilian systems in such places as South Africa, Louisiana, and other parts of the post-colonial world. I spoke on this theme about a year ago in Maastricht, thanks to a lovely conference organized by our friend, Professor Augustin Parisi, whom I must thank again. I shall point out circumstances and countries where, due to political circumstances and military conquests, where the civil law was implanted in a mother tongue, and the civil law had, of necessity, to live in English translation thereafter, or to live off of English translations thereafter. Otherwise, the civil law might have ceased to live at all. I could name quite a few of these situations, but I actually believe this topic is somewhat universal. But I want to mention in particular the case of Roman Dutch law in South Africa and the civil law in Louisiana. Of course, here at Tulane, here in Louisiana, we know part of this story in detail because it is our own history. Louisiana's dependence upon translations began with a turbulent past, a polyglot society, and a certain amount of linguistic chaos. 18th century Louisiana, and by Louisiana at that time, I mean the vast territory stretching from the Gulf of Mexico to Canada, the Mississippi Valley, was once nothing but a pawn on a global colonial chessboard. This territory was successively donated, traded, and sold with a kind of reckless speed on a colonial exchange. Consider the fact that within the space of 40 years, it was successively a colony of France, then a colony of Spain, then sold to the United States in 1803. The population did not change, not much, but each change of sovereignty brought in a different official language, French, then Spanish, then English, new governing institutions, the old French Conseil Supérieur, then the Spanish Cabildo, then American legislatures with separated powers. And it also brought in each time a new set of substantive and procedural laws. So how was the predominantly French-speaking population to keep abreast of all this linguistic whiplash? Well, much was expected from translations. Going back to the transfer to Spain, General O'Reilly introduced a cabildo, and he had translated into French parts, small parts actually, of the Recopilación de las Indias. It was only a few pages long, this translation, just enough to jumpstart an alien law in an almost epistemic void, because Spanish was not spoken by any but the troops that arrived with General O'Reilly. There was no attempt to translate the principal text, Las Siete Partidas. So Spanish law governed for the next 33 or so years behind a curtain, an almost impenetrable curtain. Then coming forward after the Louisiana Purchase in 1803, the 1808 Civil Code, our first civil code, was issued bilingually in Spanish and French. It was drafted in French, predominantly from French source materials, and then translated into English, or rather, as I think, though that might be controversial, or rather it was transposed into a kind of English juridical vocabulary. The bar and the bench at that time were now predominantly American and Anglophone, and the French language was collapsing all around them under pressure. So this English translation of the Civil Code was a critically needed translation, a means of providing access to the civil law for a bench and bar that had never been trained in civil law. They were newly arrivees into this territory. It was the first translation of a European civil code in the English language, I think. It pioneered development of an English vocabulary of civil law concepts such as, in English, obligor and obligee, services instead of servitudes, or servitudes instead of services. Louisiana was trying to create ex nihilo the first English-speaking civilians. Incidentally, the two translators, one was an Irishman and the other was a Frenchman. Neither were lawyers. Only one was a native speaker. Speed forward 150 years after that, we come to a more perilous situation. The civil law fortunes of Louisiana had reached the nadir in the middle of the 20th century. The bench and bar can no longer read French nor access French commentators and decisions. The Civil Code has aged. Some people were famously saying Louisiana had become a common law state. What to do? Well, the Louisiana Law Institute turns to a broad translation project. It decides to translate great French authors, classic works by Planiot, Aubry et Roux, and others into the English language. The project has the intended effect. Largely, it brings the French tradition within the reach of the courts and to some of the bar, and helps to create a civil law renaissance. So the remarkable survival of civil law in Louisiana, to this day the only civil law state in the United States, cannot be explained, in my opinion, without recognizing the life support, oxygen that was needed and supplied by English translations. They were good. There were good translations, there were bad translations, even amusing translations, but the general effect was extremely practical and supportive of the private law system. Now, if I turn to South Africa, I get this phrase, the remarkable survival of the civil law, from the South African scholars. According to Rena van den Berg, South Africa's civil law survived the 19th century, quote, against all odds. Well, perhaps the gravest threat to the system was there in the beginning. At about the time the Cape of Good Hope fell under British domination in 1806, Roman Dutch law was just about to disappear in Holland, the motherland in which it had been born. When Holland adopted a civil code in 1811, modeled after the Code Napoleon, the umbilical cord that formally sustained the Dutch overseas colonies was severed. The law implanted at the Cape in 1652 was cut off from a living European tradition. They would now have to go it alone. They now face the threat of assimilation under a different sovereign, in a different language, and administered by alien institutions like trial by jury. British policy was the gradual assimilation of Roman Dutch law to the common law. That was the policy. It was to be a process of subtle but persistent Anglicization. Furthermore, from a material point of view, Roman Dutch law appeared more vulnerable to the forces of assimilation than laws in other countries that might have civil codes, because this law was unwritten, uncodified, and inaccessible even for lawyers, magistrates, and administrators, not to mention the public at large. It was the law of the old Dutch authorities, from Grotius, Van Leuven, Van der Linden, Van de Kessel, Johannes Foote, sometimes written in Latin, sometimes written in Dutch, but certainly inaccessible for the new arriving British judges and the new Anglicized bar of South Africa. The language question posed a major threat from the beginning, because in 1827, English was made the sole and exclusive language of court proceedings. All judgments and orders had to be pronounced in English in open court. In 1828, the British judges, with little knowledge of either Roman Dutch law or the Dutch language, were sent out to the Cape to administer the Roman Dutch law. It was sensible for the colonial office to think that over the long term, the English language as the official language would pave the way for the common law. That actually law would eventually, the common law would follow the English language. And at that time, the very idea of an English-speaking civilian was either unknown or quite close to an oxymoron. The translations into English that began appearing at the Cape and in Ceylon and Guyana in the 19th century were principally the private endeavors of the bench and bar. There's little coordination between them, no centralization of them. I found no evidence that the translations were ever officially endorsed or subsidized by the British government. They were intermittently undertaken. They came in no predictable order. But then we began to see the translation of Simon van Leuven's work was translated as the commentaries on the Roman Dutch law. Van Leuven, who has the distinction of having invented the expression Roman Dutch law, and he incorporated the phrase into the title of his 1664 treatise. Another work of first-rate importance that was translated was Johannes van der Linden's Koopman's Handbook, the Merchant's Handbook, which was written in Dutch and published in 1806. Just touching on some of these, Foote's Commentarius ad Pandectas which is usually regarded as the most important and most frequently cited of all the institutional works. Foote, who has been called the Ulpian of Roman Dutch law, or less attractively, he was called the Prince of Compilers. But Hollow and Kahn, H.R. Hollow and Ellison Kahn, go so far as to attribute to Foote the survival of Roman Dutch law itself. Quote, "But for the Commentarius, Roman Dutch law might well have disappeared from legal practice in South Africa." What we find are that there were repeated translations of the same works over and over again, sometimes going out of print, or sometimes because there was condescension towards an earlier translation that was not considered adequate. Grotius, the father of the system, in his Enlighting, he received serial translations. Though this may be, the numbers may have been in part due to the unique importance of his revered work. So I'll just close by drawing attention to some of the general characteristics of the translations. It was a pragmatic movement with the practical goal of using English as a kind of lingua franca to bring the old authorities of Roman Dutch law within the grasp of the bench and bar. The movement was largely spurred by an English-only language policy in the courts, by a colonial policy of gradual assimilation to the common law, and by an abrupt institutional change instituted in 1828 and 1832. Nearly all of the 19th century translators were English-speaking lawyers with knowledge of Latin or Dutch, who engaged in the task of translation as an avocation and a service to fellow professionals. It was essentially a part-time activity undertaken in addition to their principal occupations. My impression is there were no commissioned, no professional translators involved. There was no sign of governmental subsidization. The translators were self-nominated or self-appointed individuals with various degrees of skills and quality. Well, I finish by making this remark. What is striking and impressive to an outside observer like myself is that an unplanned and undisciplined movement of this nature turned out to be quite effective in preserving Roman Dutch law from assimilation. Whatever the criticism that might be made or have been made, the translations permitted Anglophone jurists to read, understand, internalize, and intellectually embrace the institutional authorities. In that regard, it was instrumental in producing some of the first English-speaking civilians and guaranteed the survival of their civil law. Thank you.
Thank you, Vernon Palmer, for this presentation, which was wonderful. The next presenter is Markus Puder. And Markus Puder is going to talk about his paper that is titled "A Call for Recognizing the Place of Law and Language in Legal Comparativism."
Good afternoon. Muito obrigado, Lécia, and great to share a panel with you, Pia and Vernon. Cordial thanks also go to the organizers at UCLA, the society, and everyone joining us this afternoon or this evening in Pia's case. In the summer, I'd sent you a rather condensed abstract, not without reason. This may be not the most conventional intervention, a short abstract and a longer talk. So welcome to this presentation entitled "A Call for Recognizing the Place of Law and Language in Legal Comparativistics." Today, I would like to set this up by sharing the life change I experienced in the wake of producing in solo work the first bilingual edition, English-German, of the entire Louisiana Civil Code, along with a lengthy introduction to Louisiana law in the German language. Sparked by the surprising diagnosis that one of the most significant private law codifications has to this date not received the attention it deserves in the German and Anglo-American law and language spheres, my bilingual edition of the code, I believe, makes a contribution towards closing this remarkable gap. Beyond the ambit of the German and English-speaking world of law, the availability of the Louisiana Civil Code in yet another core European language, I hope, could even assist with initiatives to harmonize private law in Europe. Only in the wake of recent failures are Europeans realizing that legal and linguistic solutions for harmonizations could not and should not be derived from the home jurisdictions of a closed circle of unaccountable framers. For purposes of pedagogy in the New World, I envision the work as a powerful primary tool of instruction for comparative law courses. Rather than merely relying on commentary about qualifications in journals and blogs, students and instructors would not only gain direct access to the law in substance and style, but also see how law may be expressed across different languages. In the light of the wealth of discoveries I made and insights I gained in seeing through this project from start to finish, the next project phase then followed naturally. Use this translation as a case study, one that goes beyond the fields of forensic linguistics, legal semantics, and interpretation of legal texts, namely the practical application of linguistic and legal findings in the communication process between languages of different legal orders. In order to create a real-time record, this was a multi-annual project. I kept a diary to chronicle my experience throughout the translation process, not only as a translator interested in linguistic concepts and terms to solve formulation problems, but also as a comparativist exploring interrelations between different legal systems and the ways these juridical frameworks communicate the law. Let me share just a very few of those discoveries and insights. As you all know, any translation project is bounded by two big parameters: the conditions surrounding the source text and those surrounding the target text. My source text was the Louisiana Civil Code in its entirety. And so, rather unique challenges resulted from the mixed law it houses, as well as its bilingual origins. Legal mixtures have arisen not only in the wake of the common law civil law montages or dichotomies, but rather in addition, academicians of different backgrounds, temperaments, and affectations have engrafted onto the French and Spanish base other foreign law, along with new vocabulary and different drafting techniques. So this code is quite an interesting beast on many fronts. And as we just heard, Louisiana's early codifications, the 1808 Digest and the 1825 Civil Code, were originally drafted in French and subsequently translated into English. So in Louisiana, we should have a tradition of bilingual law. Indeed, our most illustrious jurists were translators and worked as translators, foremost among them Louis Moreau-Lillet, who translated the Spanish 7 divisions, but also James Brown, who is often not given the credit he, in my opinion, deserves. All the more surprising then is the fact that these jurists had nothing to do with the English translations. Interestingly, while the translation errors have rippled into modern day litigation, the identity of the widely criticized translators has never been fully explored in the literature, not until a certain Professor Palmer conducted his trailblazing work. Different but no less challenging conditions surrounded the destination language of the translation. Legal German exists in different varieties, including the legal German of Austria, the legal German of Switzerland, and the legal German of Germany. For example, the Usufruct is Niesbrauch in Germany, Fruchtniesung or Fruchtgenuss in Austria, and Nutzniesung in Switzerland. And then there is the language of the common law. For example, the closest analog is the so-called life estate, which translates to Nutzungsrecht auf Lebenszeit. Both sets of challenges combined to require careful decision-making throughout my translation process. The crucial decisions included deploying translation approaches that offered the best fit for conveying the legal message of the source text. And that legal message then transferred into the legal language of the target text. Here the spectrum ranges from implantations, neologisms, and paraphrases to different species of equivalency. Take, for example, interdiction, Louisiana's legal institution designed to protect adults incapable of taking care for their person or property. In Germany, its functional equivalent today translates to rechtliche Betreuung. In Switzerland, gestufte Beistandschaft, and in Austria, Erwachsenenvertretung, all suggesting support, dignity, and stewardship. While all these could be eligible for deeming them equivalents in function, I found conceptually more fitting the old term, the ancient term, Entmündigung, the term still used in South Tyrol. In sum, the project forced me to rethink major institutions of private law through a lingo-juridical prism, connecting substance, style, and terms across systems. So, with regards to both phases of this project, the publication of the translation, as well the publication of the manuscript, I was stunned to see the visceral resistance expressed by certain colleagues on both sides of the Atlantic. And those are generally considering themselves as gatekeepers. And they run the comparative law journals. Reactions ranged from, there is no need for such translations, to, the manuscript is too specialized for our audiences. Not so. Au contraire, I believe that the milieu of legal translation and legal comparativism continues to sharpen a comparativist senses. The craft of the comparativist is based on her or his toolkit in law and language. And now here is a selection of real-life experiences supporting the proposition I just made. The first experience would concern the world of legal transplants. When borrowing across the lines of law and language, great care must be taken in the preliminary translation phase before the implantation can even be considered. Recently, I wrote about a transplant from Germany to Louisiana with regard to the scope of personal servitudes. And this issue had reached the Louisiana Supreme Court. All the justices had to work with was the cryptic declaration by the redactor of the provision that, quote, the provision is new and based on corresponding articles in the German Civil Code, section 1091, and in the Greek Civil Code, section 1189. So what's the first logical step? Access the German model and translate it. Incidentally, Germany's Ministry of Justice has a translation on their website. It's quite an awkward one, yet fortunately enough, it's not inaccurate to a fatal degree. Yet a lawyer's statement I recently heard that original language skills are never really important because, quote, there are translations, end quote, is highly imprudent and could cause much mischief for the clients. First, the translation could be incorrect, and that has happened before. Second, how does that lawyer then, if we have nothing but that cryptic declaration, how does that lawyer then access the jurisprudence and literature from the donor jurisdiction? Yeah, which could be a way for the recipient jurisdiction to find out what this provision or the origins of that provision actually mean. Incidentally, the Louisiana Supreme Court punted this question and decided the case limited to its narrow and precise facts. The second experience concerns the world of treaties drafted in equally authentic languages. Take, for example, the design of the reference proceeding for a preliminary ruling by the Court of Justice of the European Union. it requires that the request for such a ruling may be initiated by a court or tribunal in the English language version, by a Gericht, one term only, in the German language version, by an órgano jurisdiccional in the Spanish language version, by a jurisdiction in the French language version, and by a sudni organ in the Slavic language version. So, how do certain arbitral tribunals fare under this provision? If they qualify, they are in for judicial dialogue and closer cooperation with the Court of Justice in matters of interpretation of integration law. There is now much case law on this question. It appears that the gates are cautiously opening, especially when the arbitral body is established on a legislative basis and given permanent compulsory jurisdiction. Literature now argues that arbitral tribunals hearing investment disputes, either ad hoc or under the auspices of arbitral institutions, may qualify and thus be empowered to submit references for preliminary rulings to the Court of Justice. And here, asterisk, the most open, linguistically most open version is the English one, court or tribunal. That seems linguistically a little more open. Incidentally, the European Union, especially the Commission and the Court, have invested much to have in their employ professionals with a dual qualification in law and language. Lastly, a third experience, the world of foreign law and language in domestic court practice. Through recent comparative collaborations, I have been exposed to a fascinating experience. In Russia, there seems to have been a reawakening of Roman law and legal Latin in recent jurisprudence to fill interstitial gaps in the positive law, not by reason of authority, but by authority of reason. For example, the Federal State Arbitration Court in the Krasnodar district has offered in a 2017 decision that references to Roman law are permissible in Russia, and that the Roman maxim, no one can transfer a greater right to another than he himself has, while generally applicable, does not fit in the privatization schemes after the collapse of the Soviet Union. But they used it to make the call in the case. Independent of whether this trend of elevating Roman law to the status of subsidiary law, or at least soft law to stimulate the further development of domestic law, will continue to firm up remains to be seen. But, and there's my experience, but independently, the renaissance of Roman law in Russia considerably facilitated my comparative interactions and collaborations, because my Russian is basic. I read it and have a base vocabulary, but to say I speak legal Russian would be a gross exaggeration. Yet, when the Russian is offered in conjunction with the Latin terms, I can fully make sense of it. And this was for me an experience that propelled me back, I'm not that old, back to the times of the glossators and commentators. It's priceless and humbling at the same time. So what are my conclusions? Fortunately, in the final sum of the analysis, those self-anointed gatekeepers did not prevail. My bilingual edition has been published by Nomos, and the manuscript, along with a generous and favorable review of the translation, have been published in the Max Planck Institute's Rabel Journal of International and Comparative Law. In this light, and as a comparative law society, I would call on us to collaborate, to break down the obsolete barriers between the silos of legal translation and comparative law. Panels such as today's are tremendous, and I wanted to thank all participants for making this possible. But we also need the institutional and scholarly presence and fora to have a fully recognized seat at the table. The stakes remain high, in my opinion. So I close with the timeless words of the Amsterdam jurist Isaac Kish, and I quote, and those speaking Dutch, please forgive me. Een goed translator is eigenlijk een binnen-buitengekeerd comparatist en een gooit comparatist eigenlijk een buiten-binnengekeerd translator. That means a good translator is a comparativist turned outside in, and a good comparativist is a translator turned inside out. Thank you very much for your attention. Appreciate it. Thank you.
Thank you, Markus. It was fantastic. Thank you so much. I would like to open the floor to your questions. I see in the chat that there is already a question. Do you consider that old saying that a translator has to be a lawyer too? And I believe this was directed to Markus, but we can all chime in.
If you like a quick answer, I think so. And the tragedy is that lawyers consider themselves too much of a treasure to do this work. It's hard work. And the translation of legal texts has important impacts. And so when it's done by a publishing house, by people who have all the best intentions, but not the experience, a lot of harm can be done. I would think that it's not beneath us to do this work. And not because I've really spent 2 years of almost living like a monk in this regard. Yeah. But I would say it's a total of 4 years. So it was a considerable amount of time. I didn't have any resources, but I appreciated the soul experience so as to make this point. Yeah, but I do think if it's legal texts, we should have lawyers, whether it's a solo work, a teamwork, a committee type of approach, whatever approach you may have. Thank you, Ms. Luz Miranda. Thank you.
Could I add something? Lécia?
Absolutely, please.
I couldn't agree more. Not only should a translator be a lawyer, but ought to be a native speaker in the target language, I think. Now I'm sorry, Markus, that qualifies you on in both regards. But looking back especially into Louisiana and South African history, there was a translation. The first translation ever done of Van Leuven was done in Ceylon by an individual who everyone has thought upon reading it, he could not have been a lawyer. It was a valuable translation in general, but he could not have been a lawyer. That's what Chief Justice Coetzee put in his preface when he himself later translated the same work. In Louisiana, we see numbers of examples of rather trite errors or trite confusions. One was, for example, the notion of fruits in the law of property. The notion of fruits was translated as profits. Well, that doesn't work. That doesn't work at all, because profits can be or increased revenues from any source. But a fruit is a very technical term, actually. That which is derived from property without changing its substance whatsoever, such as gathering natural fruits from trees. But profits could actually be a violation of the duties and responsibilities of a usufructuary. Animals, just the French word animaux was translated as cattle. Now, that led systematically translated as cattle. One type of animal took the place of all animals. And so I won't go into it, but I don't think that could be done by a native speaker in the English language. And as I mentioned, the two translators I was talking about in 1808, neither was a lawyer, and one was not a native speaker in English. So I think it influenced the outcome and the quality of the translation.
I have several questions here. Agustin Paredes would like to ask a question to Professor Palmer. Please take the floor.
Thank you very much. Good evening to everyone. It's a pleasure to see many friendly faces, old friends and new friends. My question is for Vernon Palmer. And yesterday in our meeting, in our panel with Michael Hoflich also, we spoke about the role of publishers and book dealers in the promotion of the transfer of knowledge. And I would like maybe Professor Palmer could elaborate of the role of book dealers and publishers in Louisiana, and if he has also some knowledge about South Africa, if they did play a role to help in this translation. Thank you.
Well, it is a crucial role. It is obviously very important if you, especially in South Africa, if you're producing so many translations, is to find willing book dealers, book publishers, and then book dealers, so that there's general access for the profession. And it's necessary to build up private collections, and private collections become the oxygen for general dispersion of the knowledge. One of the things that was important at the Cape, apparently, was that though the British took over in 1806, there already was a cache of materials built up in the Rod van Justitie. There, some 80 or 90, the classic works were there already, and therefore the material side of things was important in the transfer and continued on. Private collections were very important in Louisiana, some of the best in the country, where lawyers devoted a lot of their resources into collection of books. FX Martin had a large collection. Edward Livingston had a large collection. Moreau Lillet had another large collection. I don't know that New Orleans had an expansive publishing industry, but these books were somehow available from Europe and from other parts of the United States.
We have another question from Tom West. What do you think, and this is to everyone, what do you think about using Louisiana's English language civil law terminology when translating legal documents or even laws from French, German, or Spanish into English? Will common lawyers understand that English, or is it best to use functional equivalents, for example, servitude or easement?
It's Lécia, I would like to answer that.
Yes, of course.
I would actually prefer the term servitude to easement, especially if we go from a civil law jurisdiction such as French, German, and Spanish. One of the discoveries that I made during the translation was that Louisiana's legal English is fully functional. It's a beautiful legal English. And to read on the Ministry of Justice of Germany, to read their translation of a German civilian-based term such as servitude with easement is a little throws you off. So my leaning would be actually to go with servitude rather than easement. In Louisiana, we have this problem sometimes when it comes to taxation and classification of things. For example, a tax regulation, an ordinance, a statute might read the tax attaches to tangible personal property. What the courts in Louisiana then do is they emphasize, and that goes up to the highest court, they emphasize that this is not meant to import common law classifications, but that is strictly equivalent to corporeal movable. Yeah, and if the legal English of Louisiana weren't so functional and so fungible, actually, I would think the easement is okay. But since we have, this is one of the under-advertised strengths this jurisdiction has. I think it is even slightly, but there I might be biased, to the other big jurisdiction that can do that. That's Quebec. That's Quebec. The interesting thing is that the language switch came in 1870 after Reconstruction and the purging of all the bad provisions, taking into account that Louisiana was an English-speaking state, The interesting thing is no effort was even made for that third codification to have a second French translation. That was not even considered. And there, the drafters had no real, or that I know of, no real keen interests. But the legal English that they worked with, and some of the work was done earlier, is beautiful, and it makes sense. And so that was a long elaboration. Short answer would be yes. I would use, if we come from Germany or France or Spain, I would use servitude.
There is another question from Lukas Korporovitz. I hope I'm pronouncing it correctly. And it is to me and another one to Markus. Yes.
Yes. So thank you very much, and good evening, at least from my perspective, good evening. Thank you very much for all 4 papers, very interesting, but like you said, I have these 2 particular questions. The first one is regarding your research, Lécia, regarding this comparison between Poland and Angola. You noticed in your paper that you want to research on the historical disobedience to the rule of law. In case of Poland, I'm especially interested in to which period you're referring when you talk about the disobedience, because if we talk about the disobedience to the rule of law in Poland regarding the communist period, we very often try to trace this attitude back to the 19th century and to the partition of Poland. And many scholars are saying, well, the disobedience to the communist ideology in the second half of the 20th century was only possible because of 123 years of partition in the 19th century. So this is just clarification. So I'm interested in this. And as to Markus,
yes,
I really like your reference to the renaissance of Roman law in Russia. I am personally a Roman law scholar, so for me it was very nice. But I have a question. When I was researching for my PhD, the use of the Roman law arguments in the House of Lords, in the appellate committee of the House of Lords, there's a lot of reference to Roman law there in the judgments in the 19th and 20th century, in the early 21st century. But a lot of them is simply a rhetoric, is simply a kind of a tradition to refer to Roman law in certain cases. And when you talk about Russia, now I'm thinking maybe it is rhetoric as well. You refer to the rule Nemo plus Juris, and you noticed that after all, they didn't use it. So wasn't it rhetoric or was it substantial?
Oh, okay. Actually, thank you. Actually, in this case, they used it to make the call, but it didn't fit. It didn't fit the privatization context. The emphasis being on privatization context, but they used it as a measuring stick. So I would actually think this was more than just a rhetorical bowing to Roman law. Yet I have to say, this was more a personal experience. Yeah, so I didn't want to make a hard scientific point on this. Of course. In the minute you cross, and this is also for Tom, the minute you cross a legal order along with the language, yeah, you cannot always reach full equivalency. That's very elusive. You have to try to go for the best fit. And sometimes translators have created a new word, or they have used a paraphrase. Neither is great, because if you import an emprunt, if you import a word, then the reader in that language might have a difficulty. If you employ the paraphrase, you break the codal design, so to speak. So you could put it as an asterisk. In my translation, I've never fully seen through one approach only. Yeah, this never happened. And some of it, I don't know what I would do 2 years later, might be the mood of the day. Yeah, some of it, and the translator cannot be free of that. And sometimes I use the cop out and said the best fit. Yeah, the best fit. And especially when it comes to terms that are not easily expressed in one crisp term that suggests functional equivalency. Thank you.
Well, thank you for your question, and I appreciate it very much. The essence of my research here essentially is to rethink transplantation. And I use Poland, the Polish case, because I find it fascinating. And in the last few years, Poland has grown economically, and it is an example within the countries in East Central Europe when it comes to coming out of a socialist economy, socialistic economy, to a current definition of what economic growth is, and possibly with a lot of help of the European Union too. And so I was thinking, if the Polish case is a case of success, can I use a successful case as a reference when I am tackling the development of a legal framework of an emerging country? Can I do that? Am I being careful enough? Is it the right way to do it? Can we compare everything? And so when I talk about a historical record and use it as one of the terms for the comparison, I must say that I am looking at it from the perspective of the emerging country that is coming out of the scars or trying to overcome the scars of war, and using as a reference the Polish case as a success, as a case of success. However, and this is where translation comes in. Can we translate realities that vary? And can we translate realities that do not even exist in one particular country? What is translation? We're basically translating something based on our representations with reference to what we know. And so I really thank your question, because it goes to the heart of my challenge. Can I compare these two countries? And if I can, how do I translate the realities that are inherent to the history of these countries, so that I can set a clear ground for the comparison? And so basically, I'm calling, everyone's attention and thinking a little bit about what is the framework for the comparison that I want to construe, considering that translation is crucial. I hope this answers your question.
Yes, yes, thank you very much. Thank you. Thank you for both answers. Thanks.
Now let me try to stop sharing. Let's see. Well, I'm trying to stop the. I would suggest that if you have more questions, we have 5 minutes. If you don't have them, you can always write to the authors of the papers with your additional questions. Otherwise, I would stop here.
I think there are raised hands. Bernard Veta has raised hand, and some others too.
For some reason, I cannot see it. I shared my screen and now I cannot unshare it. But
in any case, Bernard is asking a question. So
yes, please go ahead.
Yes, this is a question to Vernon. Vernon, you mentioned the translation of various French treatises and so on and so forth. Do you agree that great parts of them are no longer relevant to the Louisiana Civil Code? Because we've adopted non-French sources in our revised code.
Well, I still find them quite useful. I think that, yes, you're alluding to the fact that there, as Markus Puder put it, there have been many hands involved in the revision of the code, and new ideas have come in depending upon the training and the skills of various contributors. But I still find the translations and the translation project, even though the works that were translated may sound out of date, they're not any longer keeping abreast of French decisional French decisions. So, or of, for example, we've had a revision of the French Civil Code in 2016. The law of obligations has been transformed to a great degree. Nevertheless, conceptually, there's just the other day I was noticing that a so-called sale with right of redemption, a sale by a person who's in need of cash and sells his property in order to receive essentially a loan, and who reserves the right to reclaim the property at a later time. An institution that is no longer really used much. There you have Planiol to really explain what's going on, to see through it and see the judges get the idea in a relatively successful transfusion of ideas from a French commentator, and the translation was done in 1959. The work was much older anyway, so it may be out of date 60 or 70 years, and still it is doing a service, I think. Someone raised their hand or put in a question, can American lawyers understand Louisiana legal in English? I think that's a good question. But couldn't they understand Potier in translation? We had the first one done in, I think, in 1802, then later by a British translator. The 1959 translation of Planiol I think it's very well done, and I think an American lawyer can understand it. Also, we have dictionaries these days, and I think it can be done without a great deal of re-education. We are threading between two legal traditions here in Louisiana, and we are a mixed jurisdiction. One of the mistakes I would like to note is that from 1808 and in 1825, the word consideration was used, thinking it would do no harm. It caused a great deal of confusion. Just even though it said causa or consideration as a test of legal validity of a contract, it did a lot of harm in that for those who were on a common law wavelength. Consideration there must have meant a very technical term. When that was brought in, I don't think enough thought was given to the possible consequences down the road. Well, those are just some thoughts.
Yeah, I wasn't saying that they weren't useful, Vernon, or accurate. What I was saying was that there are large parts of the Louisiana Code where they are now irrelevant because what was formerly a French formulation is now basically a German, from the German code. So they forget Plagniol in those areas, those particular areas, which I think are many, you know. And again, that's just my opinion.
We are beyond our time, 2 minutes beyond our time, which means that this was a fruitful discussion, an engaging panel. I am very thankful for the 26 participants who joined us this afternoon, this evening. I especially thank Pia for staying with us, and I know it is very late in Helsinki, in Finland, so thank you so much for giving us the privilege of your company and your wisdom. I thank you all. If you would like to ask questions directly to the panelists, please do not hesitate to send them an email. I will save the chat and share it with the panelists. I hope to see you next time, very soon, to keep on talking about translation, concepts, comparisons, comparative law, and finding the best method for what we do, and keep on talking this talk between lawyers and historians. Thank you so much. Have a great weekend, everybody.
Thank you.
And Markus, see you next time in South.
Okay, thank you.
And Lécia in Helsinki.
Yes.
Good to see you.
Bye-bye to everyone.
Bye-bye.
All the best, Chelsea. Bye-bye.